The Department of Education is now convening a special board meeting on Wednesday, September 5th, 2018, in the boardroom at 6300 Burlington Boulevard, Houston, Texas, at 9:45 a.m. I wish to extend a warm welcome to everybody present in this meeting of the Board of Trustees. As trustees, we're here to set goals, listen to reports from the superintendent, approve budgets, contracts, personnel appointments, and make policy for the district. It's not the role of the board to make day-to-day operational decisions. The management and day-to-day operations of the department are responsible to the superintendent. We have policies and procedures in place to resolve concerns and issues. This is a public meeting of the Board of Trustees, not a meeting of the public. Prior to this meeting, board members receive information related to items on today's agenda. Agenda items will not necessarily be handled in the order listed on the notice. The meeting is open to all who wish to attend and hear the matters discussed. During the course of this meeting, the board may determine that a closed session is necessary. In that event, the board will meet in closed session to consider matters duly posted for this meeting as permitted by sections 551.071 to 551.084, inclusive of the Texas Government Code. I respectfully ask that you please refrain from talking while others are speaking and that cell phones are turned off or in silent mode. Thank you for taking the time to join us and for interest in the Harris County Department of Education. Well, my new glasses worked. All right, I think you're going to go next, right?
Yes. Unless the board has any need to go into closed session, we can get started. Is there any reason for that? No. Okay. Purpose of this meeting is to consider the recommendation of the independent hearing examiner appointed by the Texas Education Agency and to hear oral argument in the matter of Keith Montgomery, a term contract employee who most recently served as assistant principal at HCDE's High Point East campus. I am Attorney Murphy Classic and will be presiding over the hearing today, as well as providing legal advice to the Board of Trustees in this matter. For the record, Mr. Montgomery is present. Mr. Montgomery, I understand you had an attorney for the hearing before, the independent hearing examiner in this matter, Attorney Larry Watts. Is that correct?
Yes, sir.
Is Mr. Watts representing you in today's matter as well?
Yes, he is, sir.
All right. Sarah Langlois, an attorney with, I will butcher the first one, I'm sorry. Karczewski, Bradshaw, Spalding, Nichols, Lamp, and Langlois is present and is representing the Harris County Department of Education Administration. Also present are HCDE Superintendent James Colbert Jr., High Point East Principal Marion Cooksey, and Senior Director of Schools Anthony Mays.
Just to clarify, Principal Cooksey is on campus this morning and is not here today.
I was going to say, I looked up and, all right. The following members of the Board of Trustees are present. Board President Lewis Evans, Board Vice President Eric Dick, Trustee George Moore, Trustee Dr. Diane Troutman, Trustee Don Sumners, and Trustee Michael Wolf. That's everybody.
Just for clarification.
I'm so sorry. Dr. Moore. So my sheet is not right. No, I'm just kidding. I apologize. In order to provide the most accurate record possible of this hearing, for the record, a quorum is present. In order to provide the most accurate record possible of this hearing, a court reporter is present. HCDE shall bear the cost of these services. Please avoid talking with others or speaking so the record will adequately reflect the proceedings. Mr. Montgomery, is it your desire for this hearing to occur in public open session?
Yes.
Right. Mr. Montgomery has requested a public hearing. Therefore, the parties' presentations and the board's consideration of the record and hearing examiner's recommendation will take place in open session. However, the parties are cautioned not to reveal personally identifiable information about any student in the course of this hearing. If personally identifiable information about a student will be revealed, the board will adjourn to close session under section 551.0821. Additionally, following the presentations, the board may adjourn to executive session under Texas Government Code section 551.071, so the board may consult in private with its attorney. However, no action will be taken in this executive session. Now for the procedural background of this matter. By letter dated May 17, 2018, Mr. Montgomery was notified of the board's proposal to non-renew his term employment contract with Harris County Department of Education via board action on May 16, 2018. The letter further explained that the board voted to determine that any hearing concerning the proposed non-renewal of Mr. Montgomery's term employment contract be conducted by an independent hearing examiner appointed by TEA. The May 17, 2018 letter informed Mr. Montgomery of the following. First, Texas Education Code Section 21.203B provides that the board established by policy reasons for non-renewal at the end of the school year. The HCDE Board of Trustees has established and adopted HCDE Board Policy DFBB Local, which lists specific reasons for the proposed non-renewal of an employee's term contract. The May 17, 2018 letter informed Mr. Montgomery that the proposed non-renewal of his term employment contract is based on the following reasons, any one of which is sufficient to non-renew his term employment. Section 5, insubordination or failure to comply with official directives. Section 6, failure to comply with board policies or administrative regulations. Section 14, failure to meet the department's standards of professional conduct. Section 20, any breach of the employee of an employment contract or any reason specified in the employee's employment contract, and or Section 35, any reason constituting good cause for terminating the contract during its term. The letter further detailed that the specific conduct giving rise to the proposed non-renewal of Mr. Montgomery's term employment contract stemmed from his failure to follow his supervisor's directives. The specific conduct giving rise to the proposed non-renewal of his term employment contract further stemmed from Mr. Montgomery's violations of the Family Educational Rights and Privacy Act, 28 U.S.C. Section 1232G, otherwise known as FERPA, as described in the written memoranda provided to you by HCDE's Director of Schools, Mr. Anthony Mays, including those issued on March 6, 2018 and April 30, 2018. Mr. Montgomery requested that the Commissioner of Education appoint an independent hearing examiner to hear the matter of his proposed non-renewal. The Texas Education Agency assigned a certified hearing examiner, Marguerite Gabrielle, to the case. Ms. Gabrielle scheduled and heard the matter at hand. Ms. Gabrielle then issued her recommendation, and there's a recommendation and proposal for decision that you should have seen. The hearing examiner found that HCDE proved by a preponderance of the evidence the existence of one or more reasons listed in the notice of non-renewal and therefore met its burden of proof to not renew Mr. Montgomery's contract. Specifically, the hearing examiner found that HCDE demonstrated by a preponderance of the evidence that Mr. Montgomery failed to follow official directives, Mr. Montgomery violated a lawful directive and was insubordinate, violated the Family Educational Rights and Privacy Act, known as FERPA, and breached his term contract. Based upon her recommended findings of fact and conclusions of law, the hearing examiner recommended that the Board of Trustees of the Harris County Department of Education non-renew Mr. Montgomery's term contract. Pursuant to Section 21.258 of the Texas Education Code, the Board of Trustees must consider the recommendation and record of the certified hearing examiner at the first board meeting for which notice can be posted in compliance with Chapter 551 Government Code following the issuance of the recommendation. Furthermore, the meeting must be held not later than the 20th day after the date of the President of the Board receives the certified hearing examiner's recommendation and the record of the hearing. The Board's objective today is to consider the hearing examiner's recommendation, allow each party to present argument, and determine whether the hearing examiner's recommended findings of fact, conclusions of law, and recommendation to non-renew Mr. Montgomery's term contract should be adopted, rejected, or changed. After hearing presentations, it will be the Board's responsibility to announce a decision that either 1, adopts the hearing examiner's findings of fact and conclusions of law, or 2, rejects or changes the certified hearing examiner's findings of fact and conclusions of law. The Board's decision must include findings of fact and conclusions of law and may include a grant of relief. Should the Board of Trustees determine that the certified hearing examiner's recommended findings of fact should be rejected or in any way changed, the Board may only do so after reviewing the record of the proceedings before the certified hearing examiner and only if the finding of fact is not supported by substantial evidence. The Board of Trustees must state in writing the reason and the legal basis for any change or any rejection made of the certified hearing examiner's recommendation. This hearing will be conducted as a hearing on the record. The hearing before the Board shall be based on the record of the hearing before the certified hearing examiner, including the transcript of the hearing and admitted exhibits, and no new evidence shall be submitted or accepted. Each side shall be entitled to make argument based on the record and any relevant legal or policy considerations. Mr. Montgomery and his attorney and the HCDE administration and its attorney will be allowed to make presentations. Each side will be given 15 minutes for argument. After deliberation, the Board may render the decision pursuant to Texas Education Code 21.259. And it's 15 minutes, and then there's a 5-minute rebuttal after that, so it's actually 20 altogether. Copies of the record of the hearing before the certified hearing examiner have been furnished to members of the board in sufficient time for their consideration and study. Are there any questions regarding the manner in which the proceeding will be conducted?
I have a question that I've previously lodged with the, what I would call the board services officer, the two young ladies who are seated behind me on the back row, I believe. And that is, and I've also asked the chair of the board, whether or not the proposed findings of fact and conclusions of law of both petitioner and respondent, particularly of respondent, have been included in the record, since they were a part of the record before the hearing examiner, before she issued her findings. If they have, I've been advised they have not been, and that they have not been at the suggestion of the board's counsel, Ms. Langlois. I'm asking that they be included, both petitioners and respondents' proposed findings of fact, conclusions of law, be included within the record and be considered by the board before voting. The reason for that, as will become apparent during my argument, is that we're making an objection to Michael Morath against the hearing examiner and asking that she be stricken from the roster of available hearing examiners in the state of Texas. We consider that we received a grossly unfair hearing, and I'll outline the reasons for that later.
Is there any response to that before we get started? Do you have a...
The record that was forwarded by the certified hearing examiner to Board President Lewis Evans did include the transcript as well as all of the exhibits, and that is typically the record that's included, that's delivered to the board, and was delivered to the board in sufficient time for preparation. With regards to the proposed findings of fact and conclusions of law, those were provided to the certified hearing examiner as a guide for her to issue her recommendation, which is also included in the record. I have no objection to the proposed findings of fact and conclusions of law that were filed by HCDE administration as well as by Mr. Watts within the time frame that was set forth by order by the certified hearing examiner, because Mr. Watts attempted to file two separate, what he referred to as errata, to his proposed findings of fact and conclusions of law after the deadline, and the hearing officer did not include those in the record, and I have an email to that effect stating that the only thing that would be considered or accepted would be those that were timely filed, which did not include his proposed errata.
Okay, to be clear, are you talking about the original one or the subsequent ones?
Well, actually, let me explain. I grew up in an age of legal secretaries, and I'm past that age now. We don't very often have them. I'm 76, so I dictate. And sometimes my dragon, naturally speaking, doesn't quite pick up what I intended for it to hear. So I have some significant errors, like OR will come out as ARE, or other such errors. There are, when I corrected those and had a chance to do it, we were working on a timeline. I found errors that had been ellipses, that had been overlooked by Dragon, or misspellings. So I made an errata sheet, and I made sure that it was clear that it was an errata sheet, as we use that term normally in academia, and I called it an errata. So that's what I'm talking about. It's the same thing, except that it's cleaned up without the typos or the obvious errors.
Okay, well, I don't believe that we can take on any pleadings or evidence that are new or after the deadlines from the previous.
I understand, and so if you can have it before you, whether you're charged with only considering what's appropriate, I presume. But as long as counsel doesn't have any objection to at least some form of what I have submitted, fine. This case, as you may not know, is currently in one form, a part of litigation in the district courts of Harris County. It's
I
a
object to any
whistleblower
reference
case.
to the litigation that's separate and a part of this record.
It is a part of the record. It's Exhibit 1. And consequently, as a part of that proceeding, this is going to become, I think, germane.
Well, I think if there's no objection to the errata, I mean, not the errata, but the proposed findings that were done
Originally timely filed.
then that's fine if we don't have copies of those. But are there copies of those already?
No, those were not included in the packets that were provided.
All right.
If Mr. Watts has copies of his, I have no objection to him handing those out.
Okay.
I will have them delivered to the board by email this morning. Or I'm sure that if you don't mind, I can go do that. We can take a short break and I can go call my office and have that done now.
Can't do that. What we can do though is if there's a copy of it, we can take it in
Yes.
to executive session with us afterwards. A copy of each one.
I have
And if
one
you have
copy of each one.
And that'll be sufficient. It can be passed around if the board wants to make copies at that time, they can. Let's do it that
And may I
way.
have an opportunity to examine to make sure that
Sure.
which one is being submitted?
Sure. Why don't you look at it real quickly and then we'll move on.
Thank you very much. That's fine.
Okay. Questions before we proceed? Thanks. Any other questions? No? All right. Ms. Langwell, you will have 50 minutes to make your presentation to the board based on the record. Mr. Montgomery, Mr. Watts, you will have 50 minutes to make your presentation based on the record. The HCD administration has 5 minutes for rebuttal and/or closing remarks. And Mr. Montgomery, Mr. Watts, you have 5 minutes for rebuttal and/or closing remarks. If there's no other questions from the parties, are there any questions from the board before we begin? All right. I'm going to take that silence to mean there are none. You may proceed.
Thank you. Good morning. Again, I am Sarah Langlois, and I'm
Excuse me,
proud.
I was unsure. I thought that the loser who's appealing goes first. Is that not true?
That's not typical. HCDE administration has the burden of proof, and
Yeah.
therefore we go first.
I think they have to go first. It's equal time though, so we'll hear it all.
Thank you. Again, I am Sarah Langlois, and I'm proud to represent the HCD administration this morning. The administration requests that the board adopt in full the recommendation of the independent hearing examiner in this case and non-renew Mr. Montgomery's term employment contract with HCDE. As you know, Mr. Montgomery has been an assistant principal at HCDE's High Point School East Campus. On May 16th, 2018, this board unanimously voted 7-0 to propose the non-renewal of Mr. Montgomery's term contract, with Dr. Moore making the motion and Trustee Wolf seconding. The board also voted to determine that any requested hearing be conducted by an independent hearing examiner appointed by the Texas Education Agency. Mr. Montgomery requested a hearing, and TEA appointed independent hearing examiner Marguerite Gabriel to preside over the hearing. The hearing took place over the course of 2 days, on July 17th and 19th, and lasted approximately 17 hours. The hearing was conducted as a bench trial, with both Mr. Montgomery and the HCD administration having the opportunity to call witnesses and cross-examine witnesses. The Texas rules of evidence applied. After considering all testimony and evidence, the independent hearing examiner found that HCDE proved by preponderance of the evidence that one or more reasons exist to non-renew Mr. Montgomery's contract. We are not here today to conduct a second hearing of this matter. A complete hearing has already taken place. We are here today to complete the non-renewal process and to request that the board vote to adopt the hearing examiner's recommendation in full and to non-renew Mr. Montgomery's term contract. You will very likely hear from Mr. Montgomery's attorney that all of this is a conspiracy against Mr. Montgomery. the words retaliation and violation of his constitutional rights will probably get thrown out. He'll likely even question, as he already has, the hearing officer's impartiality, as he did in the hearing. All of this is nothing more than a poor attempt to distract from the actual facts and law in this matter, all of which support the non-renewal of Mr. Montgomery's contract. The record and the hearing examiner's recommendation speak for themselves, but I would like to recap the essential facts of this case. Stated simply, Mr. Montgomery is an assistant principal who has repeatedly failed to comply with his supervisor's directives and has violated federal law on several occasions. The first reason supporting the non-renewal is Mr. Montgomery's failure to follow the directives of his supervisors, Principal Marion Cooksey and Senior Director of Schools Anthony Mays, resulting in his blatant insubordination. Mr. Cooksey, High Point East principal, directed Montgomery to report back to campus after attending a CPI training on January 5th, 2018. Yet, Mr. Montgomery admitted on the record that he didn't return to campus after the training, despite there being hours left in his workday. In another instance, Mr. Cooksey directed Mr. Montgomery to spend the day of January 9th, 2018, with Ms. Love to cover various agenda items as he transitioned to a new role. Yet, Mr. Montgomery failed to follow that directive. Then, on January 10th, Principal Cooksey directed Mr. Montgomery to complete walkthroughs of classrooms, part of his duties as an assistant principal. But by January 18th, Mr. Montgomery had not completed any of the walkthroughs as directed. Similarly, on February 23rd, Principal Cooksey directed Mr. Montgomery to meet with the high school teachers to discuss textbook issues and to issue textbooks no later than February 23rd, 2018. Yet, by March 2nd, Mr. Montgomery still had not issued any of the textbooks, again resulting in a failure to follow directives. There were at least 2 other instances of Mr. Montgomery failing to follow Principal Cooksey's directives. Mr. Montgomery also failed to follow Mr. Mays' directives, including repeated directives in writing to comply with FERPA, which Mr. Montgomery ignored as he continued to violate FERPA and disclose students' personally identifiable information. The independent hearing examiner found that HCDE demonstrated by a preponderance of the evidence that Mr. Montgomery failed to follow official directives, Mr. Montgomery violated a lawful directive, and that Mr. Montgomery was insubordinate, thereby breaching his employment contract. The independent hearing examiner concluded that Mr. Montgomery's failure to follow official directives is insubordination and provides a basis for the non-renewal of his contract. Indeed, the Commissioner of Education has repeatedly found that violation of an official directive is grounds for non-renewal. The Commissioner has stated time and time again that an educator, quote, does not get one free chance to defy a clear directive, end quote. As cited by the independent hearing examiner in her recommendation, the Commissioner has found that failure to comply with a directive is good cause for termination of a contract, which is a higher standard than non-renewal, even if there is only one instance of a failure to comply with a directive. Here, Mr. Montgomery failed to follow directives on at least 8 separate occasions. The second independent reason supporting the non-renewal is Mr. Montgomery's violation of FERPA. FERPA is the Family Educational Rights and Privacy Act, the federal law that protects 2 categories of student information: education records and personally identifiable information of students. The independent hearing examiner found that HCDE proved by a preponderance of the evidence that Mr. Montgomery violated FERPA on at least 2 separate occasions. First, when he disclosed multiple students' personally identifiable information to his attorney, and secondly, when he disclosed a student's personally identifiable information to Harris County Judge Ed Emmett, the webmaster for the Harris County Sheriff's Office, and to you all as board members. Mr. Montgomery admitted that he provided confidential, personally identifiable information, including names of students, student referrals, and other confidential information to his attorney without the written consent of students' parents or guardians, and without redacting the FERPA-protected information. Mr. Montgomery also admitted on the record in the hearing that he provided confidential, personally identifiable information, including the name of a student, the student referral, and other confidential information to Harris County Judge Ed Emmett, the webmaster for the Harris County Sheriff's Office, and to HCDE board members, again, without written consent of the student's parents or guardians, and without redacting the FERPA protected information. In total, Mr. Montgomery violated the FERPA rights of 6 High Point East students by disclosing their personally identifiable information without consent and without a permitted exception to FERPA. The IHE found that Mr. Montgomery's disclosure of personally identifiable information of students without parental consent violated FERPA, violated your board policy, FL Legal, violated the school's division standard operating procedures, and violated Standard 3.1 of the Code of Ethics and Standard Practices for Texas Educators. The independent hearing examiner concluded that Mr. Montgomery's violation of FERPA constituted a violation of the terms of his employment contract and a sufficient reason to non-renew his contract. Indeed, the Commissioner of Education has repeatedly found that unauthorized disclosure of personally identifiable information of students, including disclosing such information to the educator's attorney, violates FERPA and is a reason to non-renew an educator's contract. Not only has the Commissioner upheld terminations of contracts based on FERPA violations when educators have disclosed student information to their attorneys, the Commissioner has concluded that one violation of FERPA is sufficient to justify termination. Again, with termination being a much higher standard than non-renewal, which is what we're dealing with here. As the Commissioner explained in McGillivray versus Boyd ISD, quote, "The privacy rights of parents in their children's educational records are significant. A teacher who violates these rights has significantly failed in his responsibilities," end quote. The hearing examiner found that HCDE proved by a preponderance of the evidence that one or more reasons for non-renewal of Mr. Montgomery's term and contract exist. In fact, several independent reasons to non-renew Mr. Montgomery's contract exist, any one of which is sufficient standing alone. For these reasons, the HCDE administration respectfully requests that the board vote to adopt the hearing examiner's recommendation, including the findings of fact and conclusions of law in full, and non-renew Mr. Montgomery's Chapter 21 term employment contract. Thank you.
May I use the podium? I have a back issue that makes it easier to stand. Thank you. My name is Larry Watts. I have not had the pleasure to be before you before. I have had the pleasure to work with former superintendents of your organization. The problem with this case is that, as I told you, it was not a hearing that was fairly processed. The objections, thank you, would it be better if I just do it? The objections that I have to the fairness start at the very beginning. First of all, the witnesses that were called were all called by Ms. Langlois. I was not given the opportunity to call my own client. In fact, Ms. Langlois called my own client in contravention of West Virginia Board of Education versus Barnett, a Supreme Court case, which Ms. Langlois thought was a criminal case, but it's not. And that case says that my client has the right in these settings when he's being terminated by or losing a benefit by a governmental entity to stand silent. He may choose to dispense with that right and speak, but he has control over how he's going to react. The case at hand required that he testify, but that I was not given an opportunity to direct examine him before Ms. Langlois entered in and cross-examined. Secondly, and primarily, the hearing examiner, Ms. Gabrielle, had initially notified the Commissioner of Education that she and us, that she did not believe she had jurisdiction. She wrote that and and stated that she was going to say that she did not have jurisdiction and file that with you because this was a whistleblower claim and she had no jurisdiction over whistleblower claims. And that's true, she does not. She has no jurisdiction over constitutional claims, making determinations of whether or not a statute, the whistleblower statute, has been violated or whether the Constitution has been violated. Specifically, only the Constitution's violations can be determined by the courts, and as the Supreme Court of the state of Texas has held, that only statutory construction and violation can be determined by courts. Administrative agencies, no offense, but you are one, can't make that decision, nor can your designees like Ms. Langlois. For some reason, without ever clarifying her change of mind, she changed her mind. The next thing that goes to the fairness, so you don't have jurisdiction. She didn't have jurisdiction, you don't have jurisdiction. But there's another reason she doesn't have jurisdiction, and that's because she was a patently unfair, and I think calculatedly so, hearing examiner. There were 356 objections filed or made by Ms. Langlois. 356 evidentiary objections in 2 days. 193 of those were granted. There were 61 objections made by me. 6 of them were granted. That's shown in the record. Secondly, in the management of time, the hearing examiner, and by the way, don't forget FERPA, there's been no showing that your administration never boards proof. It has never shown that FERPA applies because that you have the predicate contract with the federal government through the accessibility of funding. You may, but the record has to show that you have funding from the federal government, from the Department of Education, that obligates you to follow FERPA. That was never shown. Secondly, it was handled in such a way that Mr. May, your director of schools, said that FERPA is in fact a strict liability statute. You either violate it or you don't, but that's not true. FERPA has multiple exceptions to it, and they have an obligation, if they're going to claim that FERPA was violated, if it's applicable, to show that each of those exceptions didn't apply. They didn't do that either. They treated it as a strict liability statute. So how did she mismanage the time? There's, the first day, it's true, that only Mr. May was on the stand. That was really torturous, for him as well. And here's why. The hearing examiner did something that I have never seen in the 52 years that I've been practicing law. I have never seen a judge ask lawyers to weigh in on what their position is about the objection that's just been made by the other lawyer. You have an objection under the rules. The judge makes a ruling. If you have an objection that's unclear, the judge says, what's the point? He then might say, do you have a response? But this went on for pages. I was at fault. I weighed in. But it went on for a full day. And in that process of those objections, the testimony, if you weigh it down, of May was only part of the first day. The second day, how did she mismanage the time? I didn't snap to what was going until the second day. And suddenly on the second day, when at noon it came up and the hearing officer came back and said, well, now I'm going to make a rule. And the rule is that in effect, Mr. Watts, you can't ask more questions, use more time to ask questions than you will allow to be to be used by Ms. Langlois. In other words, you have to judge how many minutes you're going to use and preserve at least that amount of time for Ms. Langlois. So I have to, what? I said, I object to that. We need to have a full opportunity to examine, and we didn't. She said no. Ms. Langlois joined in, and the two lawyers carried the day. The third way, at the end of the day, on the second day, I was left with a hard cutoff, and I had just a few minutes to spend at the end of the day with my client. And that's where Ms. Langlois did something I've never seen before. She called my client. I had told her from the very beginning. I've seen the listing in other administrative hearings where you say you're going to call my client, but you understand, and I understand, the Fifth Amendment doesn't apply because this is not a criminal proceeding. But the First Amendment does, because the First Amendment says my client has a right to remain silent. You can't compel speech. Well, that didn't carry the day. Next, fairness. Ms. Langlois will agree that the rules say that that hearing is to be a hearing as if it is a trial to the bench, a trial to the court. And as has been pointed out over and over and over for a very long time, motions in limine, limiting evidence, don't apply to trials before the court, to trials before the bench. In fact, I give a quote from a distinguished district judge here in Harris County who says the same thing when he's teaching young lawyers how to do it. Don't come with motions in limine. Why? Because a motion in limine is a pre-exclusionary ruling. It takes evidence out of the picture. You're charged, if you're a hearing officer, to consider only appropriate evidence. You're not, you don't have available to you as a lawyer motions in limine unless you have a jury. The second thing they did, Ms. Langlois saw that I had a 2017 version of O'Connor's Rules of Evidence. Well, if they don't change or change materially, I don't buy another book until the second year, like the legislature. Comes out every 2 years. That's what So I said that my client had a right to testify about an instruction that he was given by his principal, Marion Cooksey. And I said, they said, no, he doesn't. They, being in unison like a Greek chorus, no, he doesn't. I said, he does, because it's not hearsay. Yes, it is hearsay. I said, no, it's an exception to hearsay under 801E2D. And immediately they said, that's a 2017 version you're using. 801E2D doesn't exist anymore. It's been changed. It's not in the rules anymore. What? It's still in the rules. It's been in the rules for a long time, federal and state. Well, I didn't get to ask the question. The next thing, Ms. Langlois repeatedly said that I couldn't ask witnesses questions on cross-exam, that she had asked them on direct exam. And she was asked to explain her theory, and she was told, well, but she said, that's repetitious. If he's asking the same question I'm asking, it's repetitious. No, it's only repetitious if I ask the same question twice. Not if I ask a question another lawyer has asked. But Gabrielle, she said, I'll follow the Texas Rules of Evidence, and Ms. Langlois. So I didn't get to ask the question a number of times. Then, let's talk about FERPA. How did all this start? I'm going to read to you from that which now Ms. Langlois has agreed can go in. Montgomery's filed a civil action against the petitioner in the 270th District Court of Harris County, cause 2017-71661, grounded in alleged violations of the state constitution and Texas Government Code 55401 et sec. because the events commencing on May 9th, 2017, those events were recited in Principal Cooksey's letter memo to Mr. Montgomery, transcript 369 to 372, Respondent Exhibit 1, and it was admitted. That was about one of the few that I got. You know, the rules say that I'm entitled to have the evaluations of my client admitted. I'm entitled to have his former evaluations admitted. Those come in as a part of the rules. And yet, I was denied that. The routine, the drill was this, and I objected to that, overruled each time. The drill was this. I would say we offer into evidence Exhibit 2. It's an evaluation that goes back to the first year. I wanted to show the anomaly of how my client had been evaluated over the course of his history here and how he's been evaluated and treated during this last year. So I offered all of the evaluations, and they were all objected. They were kept out. And they were kept out because they weren't current to this year. And I offered them not only through Mr. May, not only through Mr. Cooksey, but through my own client. And they were kept out because the hearing examiner sided with Ms. Langlois. I would offer it. The hearing examiner would say, the hearing examiner is now examining evaluation, or exhibit number, it's an evaluation, shows it was signed on the blank blank 2012, 2013, 2014. Objection sustained, objection sustained, objection sustained. I felt like I was in one flew over the cuckoo's nest for a minute. It was unbelievable.
Mr. Watts, you have 3 minutes left on your time.
3 minutes?
Yes.
FERPA. My client wrote a letter when he was out. Remember, he got hurt on May the 9th last year. He tried to report an assault by a student. When he was walking away from a student, the student hit him in the back, knocked out his disc.
That's outside the record.
He was...
Objection, that's outside the record.
Yeah, if
Excuse
it's
me, it's
outside the
not
record.
outside the record. That's inside the record. So he
No,
comes
it's
out.
going to be, I'm sorry, if it's outside of the original record, it has to be sustained. I don't have it.
I know, but it's not. So and I'm sure you've read the record, you'll see the exhibits, and you'll look at Exhibit 1, and you'll see that my client was out for the entire first half of this last school year. He didn't show up until January the 4th. And the day he showed up, he got a PIP. And in that PIP, you're told by Mr. Cooksey, that's Exhibit 1, he recites the issue. He says that the events were in Principal Cooksey's letter, memo to Mr. Montgomery, dated January 4th, 2018, which recited the events of May the 9th, 2017, which prompted Cooksey's performance. So here's the point, though. I don't want to lose any more time, please. My client he was sent to high school instead of the middle school. He went to the high school because they were having a bunch of problems over there. We need you to go over there. My guy's been a star player for you guys all over these years. And he goes over to the high school, and he starts seeing things that are happening. He starts hearing things. He has students telling him. And there are a list of 34 things. You've heard of the list 34 things before. Mr. Colbert got all upset about that when we had the last hearing. Spent a lot of time reciting the 34 things. My client writes a letter to you and to the Texas Education Agency. And so they decide, they being that's where she says I came into the conspiracy theory. I don't know who decided, but someone decided we've got to make sure that there is a FERPA violation. I believe it was with all my heart planned. Because Mr. May then says, okay, you tell us who the students were, who the faculty members were, tell us who your sources were, and get that back to us within a certain amount of time. He was concerned about retaliation against his sources. He was concerned about whether or not it fell into one of the exceptions. I was having my most recent heart surgery. And I was unavailable on the 19th when the deadline was to happen.
I believe the time has
Miss-
long expired.
Yeah, I'm sorry, I was just about, Mr. Watts, you're actually about 2 minutes over, so I think we'll have to,
Can I have 1 minute to wrap up?
if you'll wrap up and then you'll have the 5-minute rebuttal.
He was drawn off sides. He never violated. He came to me. I wrote the letter. And why did we send it to you? Because the Texas Education Agency say that you're important people, and within one of the exceptions to the FERPA rule, you have a right to know what's going on. We mentioned 5 students' names. 5 students' names. He sent it to the county education, to the county judge, because the county judge is in charge of all the funding for the sheriff and for the juvenile justice program and for the probation office. And you take misdemeanors and felonies in here. And the county judge has a right to know about how the probation office is functioning over here. He sent it to the sheriff's webmaster because that's the only access that you can have to the sheriff on the internet is by going through the webmaster. And you have the sheriff's deputies down here that are patrolling and making sure safe things happen in here and protecting people. And they had their trap. And so they said, well, you can't tell your lawyer. That case that they cited, by the way, is miscited. The Commissioner of Education said that you can't tell your lawyer about stuff that comes from a student's record for FERPA if it's for purposes of progressing through a hearing process on a grievance. He wasn't doing that. He was responding to questions. I'm sorry that I took so much of your time.
Sorry. Thank you, Mr. Watts. All right. You have 5 minutes for rebuttal.
Thank you. As I stated earlier, Mr. Watts' attempt to discredit the process and to attack the independent hearing examiner is nothing more than an attempt to distract from the actual facts and law of this case. His client repeatedly violated official directives. There was no mention of that. 8 times in the record, and there were more, but at least 8. He also violated FERPA on at least 2 separate occasions. There was no permitted exception to FERPA that would allow the disclosure of confidential, personally identifiable information of students in any of these circumstances. None, and that is in the record as well. With regards to jurisdiction, the independent hearing examiner agreed that she did not have jurisdiction, as Mr. Watts said, over any whistleblower claims. That's not part of this non-renewal process. We are here in a very limited capacity, and the hearing officer had jurisdiction over a very limited issue. Is there one or more reasons to non-renew Mr. Montgomery's contract? And yes, did she exclude evidence that had nothing to do with that one question? Is there a reason to non-renew his contract? She did, and she had good reason to do so, because as is included in the record, in the transcript, numerous times in conversations with me and the hearing examiner, Mr. Watts stated that he was only using this hearing as, quote, free discovery.
Wrong.
And therefore, yes, the hearing examiner excluded evidence that was irrelevant and not material to the only issue in this matter, which is, again, does one or more reasons for non-renewal exist? The board absolutely has jurisdiction, as does the independent hearing examiner in this case. It was not an unfair hearing. Objections were ruled upon in accordance with the Texas Rules of Evidence. And additionally, Mr. Watts mischaracterizes the exchange of several objections, but I won't go into that. With regards to the time issue, as I mentioned, the hearing lasted over 2 days and was approximately 17 hours long. Just looking at the first day of the transcript, 82 pages of the transcript were of me questioning Mr. Mays. 442 pages of the transcript were of Mr. Watts questioning Mr. Mays. With regards to whether or not I was allowed to call Mr. Montgomery as a witness, the hearing examiner accurately ruled in accordance with the Texas Rules of Evidence that I am allowed to do so. I've done it in every single non-renewal and termination hearing that I've ever done. This isn't a criminal trial. He was on my witness list. I was absolutely permitted under the rules to call him as a witness. Mr. Watts could have called other witnesses had he chosen to do so. He elected not to do so. That's his choice. His client could have remained silent if he chose to do so. I've had that happen in instances in non-renewal and termination hearings in the past, and the law says that if that's the case, then an inference can be taken. But he voluntarily answered my questions. Again, I urge the board to focus on the record and to focus on the issue at hand, which is, does one or more reasons exist to non-renew Mr. Montgomery's contract? The hearing examiner, after the 2-day, 17-hour hearing, concluded that we had proven by a preponderance of the evidence that multiple reasons exist to non-renew Mr. Montgomery's contract, including his repeated violations of official directives, which is insubordination, his repeated violations of FERPA, and the breach of his employment contract. Again, the HCDE administration respectfully asks that the board adopt the hearing examiner's recommendation in full and vote to non-renew Mr. Montgomery's contract. Thank you.
Mr. Watts, you have 5 more minutes for rebuttal.
The evidence shows that there was no insubordination. Insubordination is properly defined as being the willful refusal to follow a lawful and reasonable instruction or order. That has been the time immemorial, comes out of the military definition of insubordination. And it's been adopted in every HR department that I know of that I've dealt with, including University of Houston. There was no showing Mr. Montgomery had the permission. That was where he said, I was told that I could come back. The hearing of the meeting in January, I was just out of the hospital. It was on the other side of town. It was close to where I lived. I had not had lunch. I was told if it went past lunch, I could take the rest of the day off by Cooksey. He was trying to testify to that. Oh, but you can't testify to that. That's hearsay. But 801E2D says he can. No, he doesn't. That's not the rule anymore. He didn't refuse willfully to show. He had consent. Number 2, they said that he didn't talk to Ms. Love. The hearing examiner calls her a teacher. She's the assistant principal. He did. Ms. Love was sick. She couldn't make it. Mr. Cooksey had kept him. He said, you're banned from leaving campus.
Objection, that's outside the record.
That is in...
He's testifying, and that's outside the record.
Yeah, let's just try to keep it to the record, Mr. Watts.
Well, you know, that's because they manipulated the darn record so that I didn't have an opportunity at the end of the day to call any witnesses. What they did is, let me tell you something. I intend to do this for a long time until God calls me home. But I will never be suckered into another situation where I'll lose my time on cross-examination of a witness like May by engaging in a conversation with opposing counsel and trying to explain why the opposing counsel is wrong. I'll never do that again. Judge, you call it. You've heard the objection, you call it. I'm going to get back to doing what I was doing. There was no insubordination. There was no violation of FERPA. FERPA has a major exception, and that is if you take information that's even a part of the record. But we never took any information out of the record. He took students' names because he had personal encounters with the students. He had received information from teachers who had personal encounters with the students, not record information, personal anecdotal information. That's accepted. And especially if it's information that regards the safety and welfare of students and other persons on campuses. Do you know that guy had a contract put on him by one of your students?
Objection.
One of your students put a threat, a contract on his life, and that's what he took to Mr.
He's testifying.
It's in the record.
All right, hang on one second. Hang on one second.
And that's what he repeatedly reported, and they're calling that's a FERPA violation because you told the cops about the kid.
Objection.
Mr. Watts, hang on. Everybody hang on.
That is in the record.
Mr. Watts.
All right. Do what you will.
Mr. Watts, hang on one second, please. I'm going to give you another minute for this discussion. Don't go into the facts that are not, that part is not in the record. I've read it, that's not in there. So just be sure you stick with what's ever in the record.
If you look at the notes that are in there,
I understand.
When he talks about going to the deputy sheriff, because Cooksey doesn't even do anything about it. Cooksey wouldn't report it to the sheriff's department, and he became fearful and drove out on Wallaceville Road to report it to the sheriff himself.
Saying the objection. Go ahead and go forward.
Okay. Well, I'm reminded of what we're talking about Judge Kavanaugh today. I'm reminding of what another judge said in the Fourth Circuit. He was sitting in the same place that Kavanaugh was sitting, but he wrote a wonderful opinion. And his opinion says, how can you ignore, as judges, what we know to be true as men? How can you ignore, as panel members, trusted with the civic responsibility of administering this organization, to find the truth? To find the truth. I understand that there's a great deal of discombobulation. I've talked to Paul Bettencourt. I know what the problems are. I've talked to John. I know what the problems are. But you have an obligation, as long as you're here, to find the truth. And the truth has not come from, unfortunately, I hate to say it, the right side of this table set up. Thank you.
All right. With the permission of the board president, this time the meeting of Harris County Department of Education is adjourned to executive session.
Yeah, let me say my speech.
Is that,
here.
let me give you your, yeah, go ahead.
Go ahead. You're gonna be asked something right now?
I mean, it's not normally the case, but I'm not gonna, if you have a question. You certainly can if you want to.
I do want to ask a question. So, where in the...
Who are you asking the question at?
Oh, Mr. Watts.
Turn your microphone on.
Sorry. Mr. Watts, where in the record is the motion in limine granted? Do you know?
Well, it's, I think, granted at the very beginning. And it was recited and referred to by Ms. Langlois several times when she told the judge he's violating the motion in limine. He's violating the motion in limine.
So, just to be clear, no one's disputing, Ms. Langlois, you aren't disputing that there was a motion in limine filed in a bench trial and it was granted, right? We're not disputing that?
There was a motion in limine filed, as I've done in numerous other cases in non-renewal and termination hearings as well, because the rules of civil procedure don't apply in this matter, in these matters. She did grant the motion in limine, excluding, for example, the litigation whistleblower claims, because that wasn't proper before her.
Sure. And also, there was an objection granted, and Ms. Langlois, there was an objection granted for him asking questions that you asked, like an asked and answered question, but that there was an objection. There were objections.
60 some odd times, I think.
There were numerous objections, and she ruled that she, as you hear her say time and time again, in accordance with the rules of evidence, she made rulings. Sometimes objections were sustained, and sometimes they were overruled.
But they were sustained, I'm imagining, for being asked and answered because you asked them and not him?
On memory, it was in both instances. When I was on cross and on direct, if the question had already been asked and it had been answered in the interest of time to move things along, she stated that she was making a ruling.
So your answer is yes?
I think so, yes.
Okay, thank you.
Okay, we're gonna go into executive. Nobody said else. You gonna say something?
Yes,
Okay.
please. In the, under tab number 39, the Level 3 grievance hearing before Harris County Department of Education Board of Trustees of July 18th.
Who's this for, Don?
For Ms.
Ms. Langlois? Mr. Watt, this is for Ms. Langlois. This is for Ms. Langlois.
Oh, okay.
Where is the board's determination under that hearing? You mentioned early on that we had made a decision.
Yes, sir.
But I don't have any record in any of this as to what our decision was and the wording of the decision.
Give me 1 second.
Michael, did you have
Yeah, I think so. It's along this, it's on the same topic.
Okay, I'll get you after her.
All right.
There should have been, because the hearing officer admitted, there should have been a letter from Mr. Dick that notified, even though the grievant was present, and another attorney from Mr. Watts's firm was present when the board made the decision. There was a letter written by Mr. Dick that the hearing officer admitted into evidence, explaining that the board granted the requested relief to remove one of the written reprimands. And so you will see, I think it's Exhibit 10, where that portion of the memo was redacted in accordance with the board's ruling.
Okay, so that is in the big book somewhere?
And I'm sorry I can't put my hands on it right now, but yes, sir, the hearing officer did admit that letter.
Okay. So how come that didn't appear in the section about the grievance itself?
It should have been, and that's an error if it's not.
Okay.
I just wanted to ask Mr. Watts about that decision we made in July. How do you think that should affect this hearing?
Would you say it again, sir? I'm sorry.
The grievance that we granted in July, how do you think that should impact this hearing?
I think that it should have impacted the hearing substantially, and that was what the argument that I made. When I went in on the morning after this panel had met, I told the hearing officer and Ms. Langlois that it was, and Ms. Langlois had been here. I had not, but Mr. Walhagen with my office had been, and that it was my understanding that the reprimand that had been based upon the waiting for me and the consulting with me about the matter, which was had been thrown out, and I was told that I was in error, that was not true. Later on in the day, Ms. Langlois brought a letter, and I'm not sure that it was admitted. I'm not sure it was offered, but it was a letter that was a truncated form, a shortened form of what had apparently happened. I'm not sure even it came in that day. It may have been sent by email, and I think that's the truth. It came to my office by email after the hearing, and it was requested by Ms. Langlois that it be offered into the record, and Ms. Gabrielle admitted it into the record, I think, after the close of the 5 o'clock deadline, or 5:15 as it was. So how did it affect? It apparently didn't do a darn thing.
Well, no, I'm asking, how do you think it should impact this
I
hearing
think it should have
today?
impacted the thing. I think it should have we should start off at go. I have asked in my proposed findings and fact and conclusions of law that what this board do is say, time out, we're going to set this aside, and we're going to have we're going to order that a new expedited hearing be conducted on this process. It's that important. There are enough legal and constitutional issues at stake in this matter that it's that important. And that's what I asked for. I think how it should affect, I think there are enough errors. Judge Tom G. at the Fifth Circuit used to say there are too many fish in this milk to say it ain't been watered. I think that there are too many errors that have been committed in here as to the processing of this grievance or this termination and the way it was handled to say that it should be considered as being closed or even ripe for your ruling. I didn't answer your question, did I?
I think you did.
Okay, thank you, sir.
May I respond briefly? Do you mind, Mr. Wolf?
I didn't ask for your opinion.
Okay, I'd like to have it then.
Thank you. First of all, if there's any error in the process, including about rulings on objections and things of that matter, Mr. Montgomery has the capability legally to appeal to the Commissioner of Education, who can grant that requested relief. With all due respect, the board does not have the ability to grant an entirely new hearing. The Education Code specifically says that the Board of Trustees is to consider the recommendation of the independent hearing examiner. There are very finite rules legally regarding changing the recommendation that I will leave Mr. Classing to advise you on in closed session if that is the board's desire. But a full 2-day hearing in accordance with the rules of evidence has been held by a certified hearing examiner appointed by the Texas Education Agency, and that has been done. And now the board's role is to consider the recommendation that was made. With regards to the grievance, you will see in the transcript on the morning following the grievance hearing, in the very beginning, I addressed the board's action in the grievance and explained to the independent hearing examiner that the board had granted the requested relief to have the portion of the February 20th memo that contained the written reprimand removed, and that was done in the record, and I provided the hearing officer, and it's included in the record, with the redacted portion, redacted version of that memorandum, which is in Exhibit 10. And so the board's relief that was granted in the grievance hearing affected this hearing to the extent of this one exhibit, and that was taken care of and we did not no longer relied on that written reprimand as a basis for non-renewal. Nevertheless, the hearing examiner found, again, that there was sufficient evidence in the record that for HCD to have proven that one or in fact more reasons for non-renewal existed in this matter.
Okay, now, what I'm gonna do, so we're not gonna get too much into this, I'll give you a couple minutes to respond, and I'll give you a couple minutes to respond, but I don't want to keep going back and forth. Okay, go ahead.
The sentence is this: if you don't have the authority to take to order a new hearing, I think you do, but if you don't, then I ask that you overturn and reject the termination of my client.
Okay. Ms. Linkwall, you got anything to say?
I'd just like to clarify that it's not a termination, which is a much higher legal standard. This is a non-renewal matter, and all that the department must prove is that, again, only one reason that's listed in your policy has been proven by a preponderance of the evidence that exists to support non-renewal. As the hearing examiner found, there are multiple reasons in this case to support non-renewal.
Okay. Does anybody else have any questions?
I would just ask that you provide us, I didn't bring the big books with me.
I'm
If you
happy to-
provide us
Yes,
with
sir.
that letter.
Don, you can have mine. I've got
Plenty
mine
of
right back here.
copies.
We're happy to share.
And
We're share.
I
We're
will
share.
provide the letter as well, Mr.
Yeah, we brought mine. Does anybody else have anything? Okay, hearing no other questions. Okay, under the Texas Government Code pursuant to any and all purposes permitted by sections 551.001 through 551.084, including but not limited to 551.071, we are now in executive session. It is, what was that, 52? All right, it's 11:28. We are back in session, and our board attorney has something to say.
The HCDE Board of Trustees is now reconvened in open session. No action was taken in closed session. The parties have completed their presentations. It is now time for the board to make its decision on the issues before it. The board must either adopt the findings of fact, conclusions of law, and recommendation of the hearing examiner, or reject or change the hearing examiner's findings of fact and conclusions of law and propose a grant of relief. If the board finds that substantial evidence does not support any of the hearing examiner's finding of fact, i.e. of what happened, the board must determine what happened from the record and exhibits presented before the hearing examiner. Furthermore, should the board determine that the hearing examiner did not correctly interpret the applicable HCDE board policies and/or state and/or federal law, the board may reject or change the hearing examiner's conclusions of law. A conclusion of law may also be changed or rejected if a finding of fact has been found by the board to not be supported by substantial evidence. The board must state in writing the reason and legal basis for any change or rejection. Any action the board takes must be supported by the record presented to the certified hearing examiner. Are there any discussions or questions from the board members at this time?
Anybody have any discussion, questions? No.
Is there a motion?
I move that the HCDE Board of Trustees adopts the decision and recommendation of the certified hearing examiner, adopts the findings of fact and conclusions of law recommended by the certified hearing examiner, and to non-renew Mr. Montgomery's 2017 and 18 term employment contract.
Is there any discussion? I'm sorry, go ahead.
I second.
Yes, so I have a motion by Dr. Troutman and a second by Dr. Moore. We'll have any discussion. Okay, hearing no discussion, let's have a vote. All in favor, please raise your hand. Motion passes 5-0. Do I have any other motion?
Motion to
I think it
adjourn.
was I'm sorry. I think it was 6-0.
6-0. 1, 2, 3, 4,
That's okay.
I'm-
Second.
Got a motion